Yeah, good evening. Thank you very much for coming to the third evening. Yesterday, we have looked at the privatization of international organizations, and we have seen that the organizations follow the model of their member states, reorganizing themselves according to the private law-oriented model of new public management. They also increasingly procure goods and services of all kinds, including military and security services, in order to fulfill their missions. And another novel type of partnerships, which I mentioned yesterday, private sector partnerships of international organizations, notably in the fields of environmental action, humanitarian action, development, refugees, and health, are increasing. And this important engagement of international organizations with the private sector raises similar problems as within states, but a layer of complexity is added. We here see a double delegation of public functions, from states as the principals to the organizations, and from here to the private sector, and potentially also a double evasion. I had argued that this duality does not demand totally novel principles governing privatization, but some adaptations. Today, we shall turn, as Eyal said, to the counterpart, that is, to the business side. Historically, private business persons or entities acting on the international plane were entrusted with public functions. These were notably the privateers in the law of naval warfare from the 16th to the 19th century, and the overseas trade companies from the 17th to the 19th century. I had already mentioned that in the first lecture, that especially the Dutch and the English East India companies were authorized to establish colonies, to declare war, to run prisons, and to execute persons. However, all this started before Westphalia. The companies were chartered, and the powers were granted to them before states with specific features had consolidated and were conceptualized as sovereigns. So the entire business flourished in a period in which the idea of the state as a legal person under public law and the liberal distinction between state and society was only gradually shaping up. So the situation was quite different from today. Today, we might map the involvement of private actors in the processes of public international law along the lines of lawmaking, law application, and law enforcement. Of course, these governance functions are in the international realm not neatly distributed among different branches, as in a domestic system based on a separation of powers. But still, let me begin with lawmaking. Private business actors do not possess a formal general treaty-making capacity under international law, but they have two formal channels at their disposal. First, private business concludes, as foreign investor, state contracts with host states. Rarely, some of these contracts have in the past been qualified as internationalized or transnationalized contracts. And these potentially internationalized contracts might therefore to some extent also form part of the body of international law. Second, private business actors are officially involved in international forums in which policy documents and potentially soft legal texts are elaborated. Here, private actors have a voice, not a vote, in the basically interstate lawmaking processes. For example, the General Assembly resolution on the post-2015 development agenda, leading to the Agenda 2030, formally encouraged private sector representatives to apply for participation in the UN summit. The high-level panel of eminent persons on the post-2015 development agenda, which was established by the Secretary General in 2012 to advise on the new global development framework, was supposed to include, I quote, several respected business leaders. On the website, I identified only one business leader, Mr. Paul Polman, the Chief Executive Officer of Unilever, Prior to joining Unilever, Mr. Pullman was Chief Financial Officer of Nestle SA. Nestle, infamous for its breast milk substitute campaign in developing countries in the 1970s, and today the world's largest brand of bottled fresh water, involved in the water wars of Latin America, I'm not sure whether out of all firms Nestle is the ideal, respectable business. Second, besides these formal channels, business actors naturally seek to lobby and use their informal connections, just as they do in the domestic political process. Of course, they try to influence the state's international lawmaking activities before or in the course of diplomatic treaty negotiations. As I said, most formal participation schemes and accreditation schemes at international conferences at which lawmaking, or at least soft lawmaking, happens, for example, at environmental COPs, G20 meetings and the like, do treat the for-profit business actors as a separate group distinct from the not-for-profit civil society actors. However, business actors also infiltrate and try to hijack the civil society participation in international lawmaking forums. Such a masquerading of business as civil society is not too difficult, because the boundaries between public interest related and not-for-profit actors on the one hand and business actors on the other hand are blurry. That should suffice now for business participation in the multilateral interstate lawmaking forums. I would now like to turn to a completely different type of norm production, and that is global standard setting. We are here speaking about industrial, professional, company standards, including purely technical standards, but also ethical standards. For example, international financial and accounting standards, labor and environmental standards, such as individual firms' codes of conduct, or social standards, such as ISO 14000, or the Kimberley-Blood Diamond standards, or the worldwide responsible apparel production principles, and so on. These phenomena have been intensely studied both by lawyers and by political scientists, for example, by Jan Wouters, who's sitting here. Another scholar, Hans Schepel, has characterized the standards as follows. Standards hover between the state and the market. Standards largely collapse the distinction between legal and social norms. Standards are very rarely either wholly public or wholly private, and can be both intensely local and irreducibly global. It is meanwhile, in descriptive terms, quite obvious that most modern standard setting happens in a trilateral public-private setting among states, NGOs, and business actors. The normative assessment of these standards is mixed. Much depends on the issue area. Some sets of international standards are effective and work, others not. Initial legitimacy problems have been tackled by increasing transparency and civil society participation. International or global standard setting has revived an ancient debate of legal theory, namely the debate on legal pluralism, and it has transferred this paradigm to the global realm. The question of legal theory in this context is which norms count and should count as law, and whether the state enjoys and should enjoy a state monopoly on lawmaking. The strong legal pluralist position asserts that real law can emerge out of society too. This would potentially mean that the private actors are real lawmakers. This debate risks to exhaust itself in labeling. It is a matter of definition and convention what to call a legal norm as opposed to mere social non-legal norm. Are the Forest Stewardship Council's foresting standards law? Is the Declaration of Helsinki on medical and ethical standards law? Is the Code of Conduct issued by the pharmaceutical company of Novartis law? And what about the 2013 Accord on Fire and Building Safety in Bangladesh, which so far has been signed by 215 garment brands and retailers and trade unions to make the Bangladeshi garment industry safer. You know that this had happened after a fire incident in a plant which had killed over 1,000 workers. Is this law? The functions of these and of numerous other standards produced by or with private actors can be analyzed upon their interplay with the relevant state-made law in the relevant issue area. The privately made standards sometimes prepare state-made law, or they complement state-made law, or they even substitute it. I think that the main function is the complementary function. Standards created by private actors are combined with state-made law through the techniques of renvoi, referral, or incorporation. And through these referrals, then, privately made norms deploy a hard legal and legally binding effect. A shining example of private norm making, but only until the financial crisis of 2008, had been the International Financial Reporting Standards adopted by the International Accounting Standards Board. These standards were then incorporated, or are continuously incorporated, in the EU Commission regulation, whose annexes, which contain the standards, are being continuously amended. However, after the financial crisis of 2008, national regulators expressed their mistrust. A.L. Benvenisti also mentioned that in his Global Governance handbook, pocketbook. So after the financial crisis, this seemed to be too private, and a new monitoring board, including representative of public actors, was established. Now, if we attach the label law to some of these standards, the ongoing proliferating standard-setting activity has brought to an end any public monopoly on lawmaking, if such a monopoly ever existed. But what about the presumable state's monopoly on ultimately allowing the enforcement of these norms in public institutions such as courts? Besides public enforcement in court, there are private mechanisms of norm implementation and of norm enforcement, such as NGO certification and arbitration. The question is how effective these private enforcement mechanisms are. A study conducted by the political scientist Richard Locke on private labor standards, based on a 5-year field research with 700 interviews conducted between 2005 and 2010, makes the argument about the limits of these private initiatives and the need to bring the state public regulation back into the picture. I quote the author: "Factory managers, let alone company directors, cannot be convinced that it is in their own self-interest, the so-called business case, to pay workers higher wages and to embrace independent unions. This is why government regulation is required, because only the state has the authority and legitimacy to enforce labor legislation and to protect citizenship rights." End of quote, Locke. He continues, "Bringing in the state in this case doesn't mean a return to traditional command and control regulation, nor does it imply that we simply ignore or bypass the myriad private regulatory efforts currently in place. Rather, Locke argues that the most effective and sustainable approach to ensuring labor standards and workers' rights in the global supply chains will require a mix of novel forms of public and private regulation. Because public regulation alone is unable to effectively regulate the issue too. What is needed, also according to this new study, is the so-called threat of sanction, less as to force suppliers, but more as a background condition or a fallback mechanism. To conclude, international lawmaking has been privatized to a large degree. More even, it seems that lawmaking can no longer function as a public-only policy. However, as in the other areas of privatization, we see that the quintessential public actor, the state, is still needed as a guarantor In this field, we could say, as a guarantor of the legal order. Any norms produced in public-private collaboration, in so-called standards ventures, are rendered more effective and more legitimate by the shadow of the state. I would now like to leave the law production and turn to law application and law enforcement in two prominent and peculiar issue areas, Internet and investment. Since its creation in 1969, the Internet has been a public-private partnership, but a very special one. The Internet has two characteristics. First, the absence of an authoritative superordinate authority and oversight of states, and second, a predominance of technical and market-based considerations for all governance decisions. Internet governance is an extremely complex affair. Mark Raymond and Laura Dinardis distinguish 6 functional areas. First, the control of critical Internet resources. Second, setting Internet standards. Third, access and interconnection coordination. Fourth, cybersecurity governance. Fifth, information intermediation. And sixth, architecture-based intellectual property rights enforcement. In these 6 areas, the authors have identified as much as 43 different governance functions. And these functions are performed by various private and public actors, firms, states, international organizations, and civil society organizations. Here, the private, and that is academic, technical, and business actors, have historically played a leading role, plus the United States and California. The Internet was never fully and exclusively private, but not the least due to its technical character, it has traditionally been dominated by private actors. Importantly, private actors own the majority of the underlying infrastructure that supports the cyber domain. And they also possess some of the know-how how to run it exclusively. This ownership structure means that private parties may be responsible for implementing policy choices made by the public actors, by the governments. It also means that private parties have a vested interest in most policy decisions concerning cyberspace. Cyber therefore starts from the opposite baseline from most other legal regimes, where states operated first and private parties have only recently begun to operate in ways similar to governments. Nevertheless, in current Internet governance discussions, an all-private model of Internet governance is no viable option. States consistently veto proposals for a complete privatization of the Internet. All states take some governmental involvement in international cyber governance as a given. States only diverge on who participates and who controls how much. So the question is only about the concrete balance between private and public actors, private and public norms, and private and public objectives in Internet governance. The struggle about the proper balance between public and private is manifest in the current controversy over multilateralism versus multi-stakeholderism. As it is well known, China and Russia repeatedly propagate a multilateral, and that is an interstate or intergovernmental model of cyber governance, under the lead of the International Telecommunications Union, the ITU. This would be the publicization of the Internet governance. But because of the pre-existing constituency of private parties that are accustomed to participating in and having a major influence on cyber policy issues, the multilateral model of Internet governance, which China and Russia advocate, would not enfranchise private parties in cyber governance, but would on the contrary rather disenfranchise private parties that have participated and even controlled governance for decades. The United States and other Western states therefore favor multi-stakeholderism as opposed to multilateralism. Under the broad heading of multilateralism versus multi-stakeholderism, we must, as I said, look at the actual public-private distribution of specific governance function. I will give only one example, namely the task of assigning top-level domain names. In 2016, the United States withdrew from this task. This is, on one level of analysis, a step towards privatization of this specific internet governance function. But as we have seen yesterday, the recalibration between public and private law and global governance often, not always, but often also implies a recalibration between international law and domestic law, because the relevant private law will often be domestic law. This is clearly the case for the regulation of the internet. The United States play a historic role. Private actors are mostly regulated by US domestic law. They are not regulated by some free-floating lex electronica. So the privatization of a governance task here is also a domestication, namely a move towards US law. The real underlying issue is free speech. As Jack Goldsmith and Tim Wu have pointed out in their book Who Controls the Internet, nearly every debate about internet governance is at the bottom a debate about free speech governance. Attitudes on free speech diverge between Russia and China on the one hand and the US on the other hand. But the regulatory approaches of the United States and the European Union to balancing free speech against protection of privacy also differs markedly. The clue is now, as argued by Karl Raustiala, that the move towards privatization performed by the United States, as manifest in its pulling out from the assignment of top-level domain names, in reality entrenches US hegemony. It entrenches US hegemony by evading critique against the formal hegemony and by relying on US-based companies and stakeholders. These private actors exactly espouse US values, notably extremely free and unregulated speech, and they are governed by US law. So I turn to the next regime, investment. The second regime, in which a recalibration of the public and the private is currently ongoing, is the international law of foreign investment protection. Here, private actors, the investors, have been equipped with own procedural and substantive rights flowing from international law instruments, opposable against foreign host states, and with help of which they can pursue their own private interests in secure conditions for investment. At the same time, by doing so, the investors enforce the objective law of the relevant bilateral or multilateral investment treaty, a treaty which presumably lies in the public interest of the two involved states. The public interest of the capital exporting states in the facilitation of capital flow, and the public interest of the host state in attracting capital, balanced against its other regulatory objectives. Speaking of this public interest, we should add that there seems to be no empirical evidence that the conclusion of BITS had actually promoted foreign investment. Also, foreign investment has been tainted by corrupt collusion between host states officials and business. So as a social fact, host states have welcomed investors not necessarily in the public interest of their population, but in the private interest of their governing elites. However, the law on the books has emphasized the public interests. The preamble of the ICSID Convention places private foreign investments in the service of economic development and international cooperation. The ICSID preamble begins with the words, I quote the preamble, "The contracting states, considering the need for international cooperation for economic development and the role of private international investment therein," and then it goes on. Also, the usual preambles of BITS cite the strengthening of economic cooperation between the states parties or the increase of the prosperity of peoples as overarching goals of the treaties. From this perspective, the investors are also, or maybe even primarily, trustees of these public interests. An ICSID tribunal formulated this idea as follows, I quote SGS against Philippines. Although under modern international law, treaties may confer rights, substantive and procedural, on individuals, they will normally do so in order to achieve some public interest. As you know, the designers of the ICSID system deemed it necessary to equip the investors with own rights because the home states typically have additional political, geostrategic, or other interests that may conflict with the private economic interest of its investors. In fact, home states are hardly interested in the claims arising from bids and in the state contracts or in their enforcement. This shows in the fact that in arbitration proceedings instituted by businesses, the home state of investors are far more likely to intervene as third parties in favor of the respondent state, rather than in favor of their own business. This suggests that the juridical emancipation of the investors by granting these private actors autonomous international legal rights to file arbitration requests is not superfluous. A different privatized feature of international investment protection is that its dispute settlement system is modeled on purely private commercial arbitration. It is based on the consent of the parties. The arbitration procedure has been at least initially confidential and secret, not public. The decision makers are arbitrators, not judges. They are not neutral and independent. The desired even-handedness of the decision results from the fact that the arbitrators, with their opposing inclinations, the one selected by and leaning in favor of the investor and the other one selected by and leaning in favor of the state, will have to compromise under a chairman so that their biases will neutralize each other. That's the idea. Overall, the entire original design of ICSID was to find a fair balance between public and private. Aaron Brosh, then General Counsel of the World Bank, the mastermind behind the ICSID system, describes his idea as follows, I quote Brosh. The purpose of the convention is to promote foreign investment by improving the investment climate for investors and host states alike. The drafters have taken great care to make it a balanced instrument, serving the public interests of host states as well as private investors. But contrary to what Brosh had aspired to, the real takeoff of the system since the 1990s showed that this balance was not proper and needs some adjustments. Heavy critique has been directed against this skewedness in favor of the private actors to the detriment of public interests. The new generation of investment agreements already in force or under negotiation, such as CETA and TTIP, is therefore laudably incorporating more public-like procedural guarantees, namely public procedures, more extensive review, and state-nominated investment judges as opposed to party-appointed arbitrators. For example, the Canadian-European CETA, as now signed by Canada and the EU bodies, and ready for provisional application pending ratification in all EU member states, foresees a joint committee for settling investment disputes. This joint committee would probably amount to a hybrid public law, private law dispute settlement institution. In substance, new public law elements of investment protection might be ordre public clauses in the investment treaties, and these would allow host states to adopt legitimate measures in the public interest without breaching the investment treaties, and further new substance, in order to mitigate the preponderance of private investor interests, would lie in imposing obligations on investors in the bids, such as obligations to respect not only the domestic law of the host state, but also international human rights. A recent example of an investment award moving towards a more stringent examination of the host state's public regulatory interests and the investor's public international law-based obligations is the award Urbasa versus Argentina, issued in December last year, which I also referenced on the handout. This is the first time an ICSID tribunal examined a human rights-based counterclaim filed by the host state on its merits. Again, this case arose out of water privatization in Argentina, again in the province of Buenos Aires. The investment tribunal summarizes the facts as follows. Before the 1980s, Argentina's federal government provided drinking water and sewage services through the Obras Sanitarias de la Nación. When the funding from the federal budget became subject to severe restrictions, the services provided by OSN went into great difficulties. In 1996, a report of the Inter-American Development Bank described the legal, institutional, operational, and economic situation of the drinking water and sewage sector in Argentina as traumatico. So Argentina promoted private sector involvement since the early 1990s because it was thought that only the private sector had the technical and financial capacity. The private sector was expected to secure expanded coverage, quality and efficiency levels, and to provide access to water to much larger parts of the population than before. The Spanish consortium entrusted in 2000 with the concession for water and sewage services was Urbasa. Urbasa was in the following treated badly, and the province of Buenos Aires terminated the concession after 6 years. Urbasa requested arbitration on the basis of the Spanish-Argentinian bid and claimed a breach of fair and equitable treatment and expropriation. Ultimately, Urbasa's claims failed. The interesting point is now that Argentina filed a counterclaim for damages on the basis of Urbasa's alleged failure to provide the necessary investment into the concession, thereby violating its commitments and its obligations under international law based on the human right to water. That was the counterclaim. The tribunal ultimately rejected this counterclaim, but it made some important statements on the corporation's human rights obligations. The arbitrators stated that the corporation does not have a positive obligation to fulfill the human right to water directly, flowing from international human rights law. I quote the tribunal. The human right to water entails an obligation of compliance on the part of the state, but it does not contain an obligation for performance on the part of any company providing the contractually required service. Instead, only the state has the international human rights-based obligation to perform, as the tribunal calls it. Such an obligation to perform the water service, says the tribunal, cannot be imposed on any company knowledgeable in the field of provision of water and sanitation services. In order to have such an obligation to perform applicable to a particular investor, a contract or similar legal relationship of civil and commercial law is required. In such a case, the investor's obligation to perform has its source in domestic law. It does not find its legal ground in general international law. End of quote of the tribunal. Also, the tribunal insisted on the state's primary responsibility to exercise its authority over the concessionaire in such a way that the population's basic right for water and sanitation was ensured and preserved. For such a primary obligation to be properly exercised by the state, it was certainly not sufficient, says the tribunal, to call upon the concessionaire to comply with the service optimization and expansion program, says the tribunal. To conclude, this new award, Urbasa versus Argentina of December 2016, fully confirms the embedded liberalism Ruggie framework, namely insisting on the strict obligation of states, including obligations to regulate and to supervise the concessionaires, but no direct international human rights obligation to fulfill for the private companies. The private corporations are fully mediated. Their human rights related obligations flow only from domestic law, be it contract or statute. The Urbasa Award has brought us back to the question of human rights limits on privatization, which poses itself not only in foreign investment, but generally. I have already in the first lecture spoken about the state's obligations in this context. I would now like to look at the business side. As it is well known, the UN Guiding Principles on Business and Human Rights of 2011, the Ruggie Principles, postulate obligations to protect human rights for states and human rights-related responsibilities for business. The operationalization of the Ruggie Principles is ongoing with so-called National Action Plans, NAPs. The EU Commission tasked the EU member states to develop NAPs. Germany, for example, has published its NAP in December last year. In lecture number 1, we have seen an intensification of the state's obligations to regulate and to monitor, and also a proceduralization of these obligations. France has, just some days ago, espoused this regulatory obligation and has adopted a law as an amendment to its commercial code in which it imposes due diligence obligations, obligation de vigilance, and human rights impact assessments on private firms which have their social or their formal seat in France. I also referenced this new law on the handout. Very importantly, the due diligence obligations of the corporation covers all activities of subcontractors and suppliers with which, to quote the law, an established commercial relation is entertained if their activities are attached to this relation. In this lecture, I can't speak about the corporate obligations generally. I only want to come back specifically to privatization. The Ruggie principles contain one section entitled The State-Business Nexus. The principles mention different degrees of nexus, ranging from high to low, and principle 5 is the most pertinent one for actual privatizations. Principle 5 states that, I quote, states should exercise adequate oversight in order to meet their international human rights obligations when they contract with or legislate for business enterprises to provide services that may impact upon the enjoyment of human rights. That's principle 5. The commentary says that states do not relinquish their international human rights obligations when they privatize the delivery of services. In this Ruggie framework, the commentary's prohibition on states to relinquish their obligations seems to extend very far. Many types of privatization may have an impact on the enjoyment of human rights. Also, may impact is less than encroachment of or interference with. Finally, this Ruggie principle does not include a jurisdictional limitation to this state obligation to protect and ensure through adequate oversight over providers. We know that under the human rights case law as it stands, the state's obligation to abstain from directly and actively encroaching on human rights itself are triggered only where the state has jurisdiction. Jurisdiction in the sense of control as a kind of threshold. Jurisdiction as a proxy for sovereignty to which the human rights responsibility is attached, which is not a problem inside the territory and therefore discussed only for extraterritorial state action. But the state's mere oversight and ensure obligations over private actors seem to be extended more broadly, here by the Ruggie principles and also in much of the scholarly debate. Oversight and ensuring obligations do not seem to be triggered only within the state's sphere of control. There seems to be the expectation that such regulation may or even must be extended over firms located abroad as long as there is a link to the regulating state. For example, through the firm's nationality. I do not think that this expectation has already given rise to a clear rule in the law as it stands. Human rights law seems to be in flux. The mentioned Ruggie principles concern the obligations of the states when they privatize public tasks, functions, and services. And I would now like to turn to the private service providers themselves. Under international law as it stands, and as a general matter, international human rights treaties do not directly regulate the conduct of corporations. And therefore, such conduct cannot violate human rights treaties per se. Neither have customary law-based hard and direct human rights obligations of private business actors emerged. In contrast, human rights-related duties of business may be called indirect obligations, based on a so-called indirect third-party effect of human rights treaties, or in the language of the Ruggie principles, as mere responsibilities short of legal obligations. There is a scarce case law of the regional human rights courts and the universal treaty bodies on the particular situation of privatization of functions and services. When states have privatized, And when they have outsourced previous public functions, for example, to private schools, private homes for the elderly, private hospitals, and so on, then the private service provider's harmful behavior can be directly attributed to the state. This case law of the human rights institutions is, however, not fully coordinated with the principles of attribution under the general law of state responsibility. After a privatization program, the private actor will typically not be under effective control of the state in the sense of Article 8 of the ILC articles, and it will typically not exercise elements of governmental authority in the sense of Article 5, as this concept has been narrowly understood by the ILC. The case law, nevertheless, sometimes implicitly applies special and more relaxed attribution criteria, which easier lead to a direct attribution of misconduct of a private actor exercising a traditionally public function to the state. The classic case is the case of a teacher of a private school abusing a child. And these rules, could function, I think, as a lex specialis to the ILC articles on state responsibility. But that's a very specific situation. The policy question is now whether, even beyond the confines of privatization in a narrow sense, in our contemporary era of unbridled global corporate power, international lawmakers need to react to globalization and should directly subject private actors, at least huge transnational corporations, to international human rights law in the future. This is what a group of mainly capital importing states is campaigning for in the UN, notably in the Human Rights Council. These states, Ecuador and so on, are in favor of a binding international convention codifying direct corporate human rights obligations. The USA and the EU have already explicitly pronounced themselves against such a convention. So the political prospects seem quite dim. But let us step back and analyze this fundamental question. This may be the fundamental question of the entire lecture. Should powerful private actors such as transnational corporations be directly bound by international human rights? My answer is no. And this answer has to do with the public-private split. I give two main reasons for my proposition. First, private actors and public actors live under different, even antagonist guiding principles, namely liberty for private persons and legality and boundedness for public persons, respectively. Private business actors themselves also enjoy the human right to property, freedom of enterprise, and freedom of contract. They therefore start from a completely different baseline than the state, which is under the rule of law from the outset on limited by law, having duty-bound competences rather than rights. Second, the type of power and social control exercised by private business is in structural terms different from state power. Private actors do not have the power to formally impose binding laws on third parties. They do not have the power to enforce law by physical means. But is this distinction between public power and private power still tenable in times of globalization? Three traditional forms of private power have been much fortified recently. First, business has gained power on the market, exploiting laborers and setting prices. Second, business has gained power to lobby or corrupt the public lawmakers and law enforcers, and thereby to indirectly influence domestic and international lawmaking through legal or illegal means. Third, the phenomenon that wealthy entrepreneurs become politicians, naturally prone to serve industries and their own interests without a proper policing of conflict of interest, is rampant. The revolving door phenomenon, namely high-profile professionals moving back and forth between the governmental and the business sphere, is widespread. US President Trump is just a recent example. Against this background, can we still accept that, to quote again Chicago School economist Milton Friedman, that the social responsibility of business is to increase its profit? The idea of non-profit related corporate social responsibility, CSR, emerged already in the 1960s and has even more ancient roots in the law of corporations. CSR has now entered the law as it stands. A recent example is the EU Corporate Social Responsibility Directive of 2014. The EU CSR Directive prescribes non-financial reporting on environmental, social, and employee matters, on respect for human rights, anti-corruption, and bribery. The corporate social responsibility must be realized through certain procedures, due diligence processes, and impact assessments. And the sanction for non-compliance with the obligation to pursue the relevant policies is also only a procedural one, namely an obligation to give reasons. This is the comply or explain scheme. Despite the acceptance of corporate responsibility, the prevailing view is still that the power of business is not sufficiently similar to state power so as to warrant direct business human rights obligations. Against this standard view, it might be questioned along a critical line whether the construction of the state power as the normal power and the construction of business power as a distortion of the perceived normalcy of state-centered power is still adequate. Is it sufficient, as I have suggested up to this point, to frame the responses of public international law to private governance, their governance activities, and their concomitant potential for harm around some reaffirmation of state power or state responsibility? We have seen that this is indeed the response of basically all law and policy documents which I examined, to tighten and to proceduralize the state's regulatory and monitoring obligations. One flaw of this approach may be that those policy responses presume clarity and consensus surrounding the state's role. But this role of the state is actually not really clear and may not be universally shared. If we look, for example, at patrimonial states in Africa and at religious states in the Arab world, we see different images of the state. I think that we must take the critique of the distinction between state power and corporate power, which is of course at the same time a critique against the public-private distinction, seriously. The public and the private spheres, the powers of the state and of the corporation, sovereignty and property are mutually constitutive, and they have both been constituted by international law. The variance of capitalism, the rise and fall of state-like companies and of commercialized states, the waves of deregulation, re-regulation, privatization, and nationalization are continuously blurring and shifting the various public-private boundaries. But, and I here repeat my main proposition, despite this blurriness, and despite the historic contingency, and despite the multiplicities of public-private boundaries, the basic idea of drawing public-private distinctions remains a useful analytic tool and a normative guideline for distributing governance tasks on different actors we call public and private, and for using different legal instruments we call public and private. Specific and tailored legal obligations must be imposed on private actors in order to secure basic values. I called them constitutional values yesterday, but without simply extending the rules that have been designed for public actors to the private sphere. For example, the values underlying the human rights norms need to be inserted into specific rules for business. And these specific rules will also have to be interpreted in the light of international human rights. This should happen both on the international and on the domestic level. In the context of privatization, the relevant principles could enter statutory or treaty law, and notably the individual contracts with the service and goods providers. The exact content of the legal obligations imposed on private actors depend on various factors. The first factor is the intensity of the public-private nexus. Second, the obligations need to be sector-specific. For example, the privatized governance of the Internet should follow different legal parameters than the privatized governance of water supply. But the more the structural differences between private and public power are erased in times of globalization, the tighter legal constraints on private actors are justified in order to secure the values of security, freedom, equality, and decent livelihood of natural persons. I come to my conclusion. First, any delimitation of the spheres of the public and of the private, and of public law and private law, has always been relative, blurry, and contested. If we use the public interest versus the private interest orientation as a possible distinguishing criterion between the spheres and between the actors, we see this distinction eroded from both sides of the boundary. The public interest orientation of the public actors is called into question by commercialized states on the one hand. The private profit interest orientation of business is mitigated by concepts such as corporate social responsibility and social and solidarity economy, by so-called benefit corporations, which is apparently a new legal form recognized in a number of US American states, and by so-called philanthrocapitalism, such as the Bill and Melinda Gates Foundation. Second, the continuous rise of private corporate power is not just an accident or a force of nature, but has of course been fueled by public international law itself. As Horatia Muir-Watt wrote in an important programmatic paper on private law beyond the schism, I quote her, "The fundamental paradox of international law is that the supremacy of its public dimension, dealing with relationships between its sovereign subjects, has led to an extraordinary empowerment of the private, demurely masked all the while by its neutral, apolitical stance. Reining in this private corporate power is necessary to realize values which are often tagged public, but which could, as I said, also be called constitutional values, spanning the public and the private sphere. These constitutional values are security, protecting the weak, safeguarding liberty and equality of natural persons, a minimum decent life for all, protecting the natural environment, and the diversity of cultures. It is an ongoing challenge which is best met, I submit, by upholding in our social and political imaginary the various public-private distinctions, however relative and stereotypical as they might be. Upholding them means buying into the old-fashioned liberal idea that exploiting the pursuit of each community's members' particular private welfare by exploiting their resources in terms of money, expertise, infrastructure, manpower, and flexibility is just a different, indirect way to also, or maybe even better, reach objectives in the general public interest. Acknowledging the excesses of neoliberalism, corporate scandals, and systematic deprivation and skewed distribution, I submit that the historical experience shows that other forms, illiberal schemes of organizing economic and political life, based on a negation of the distinction between the public and the private, have worked even worse for populations and for the environment. For scholars of international law, the distinction, with all its contingency, between private law features and public law features in international law remains, I submit, a useful heuristic device and a regulatory idea. But, following Hersch Lauterpacht, we should not overestimate the power of public international law to regulate private actors directly, but should seek to harness domestic law, including specifically domestic private law, to safeguard some basic values. Although, as Lauterpacht said, international law is at the vanishing point of law, it will not vanish completely if we continue to use it with moderation.